All right. My name is Craig Henry, citizen journalist reporting from the Vermillion County, Indiana jail, where I am being held as a political prisoner by the state of Indiana. More specifically, the public officials that inhabit the positions of power in this state. This is my 7th day as a prisoner in the jail. I'm not eating any of the food they are bringing me. The trays, I don't trust them. I don't trust my captors. I have not been checked on by any nurse or medical staff, and it is my 7th day, which is most likely their way of avoiding documenting my severe weight loss that is being precipitated by their chosen form of retaliation, what I would call torture. At my last court date, I appeared alongside my attorney, Elizabeth Smith. We were bamboozled when Judge Hunter Reese, that is my judge, announced that Sullivan County, Indiana, had issued a sealed warrant for my arrest. The judge then held a bond revocation hearing. Usually at these hearings, a judge hears from the state's attorney arguments as to why a bond should be revoked. That didn't happen in this case, though. The state's attorney, Bruce Ackerman, requested time to look at this case, at the new case from Sullivan County, before revoking my bond. My attorney, Elizabeth Smith, requested the same time to prepare a defense for a bond revocation hearing. At this time, neither the prosecutor nor my attorney had seen the charges or probable cause from Sullivan County, Indiana, which, to my knowledge, is still the case. So at the time of that hearing, on October 16th in Vermillion County, it would have been impossible for either the state's attorney or my attorney to argue a bond revocation hearing. All right? The judge then, of his own volition, said, well, despite either side asking for more time before revoking the bond, I'm revoking it anyway. It is important to note that Judge Hunter Reese is an ex-law enforcement officer. This is, in my opinion, more than enough motive to want me thrown in a cage like a dog, as he has now done 4 separate times. Not only that, but the prosecution has added my attorney to their witness list in Vermillion County, which is where I'm going to trial on November 19th through the 21st. This could be problematic, as it is totally unconventional for a defense attorney to also be a witness at a trial. The government promotes a story that convinces people of the normality of this case. They want to paint me as just another criminal, and this case is just another case. The reality is that there's nothing normal about kidnapping a journalist to prevent further corruption and wrongdoing from being exposed. Some may recall my report a year ago exposing corruption and illegal activity within the city of Clinton and the city hall of Clinton, specifically the mayor's office, Jack Guilfoyle. The link to that video will be in the description below. As I said, that video dropped about 1 year ago to around this exact date. Coincidentally, the mayor of Clinton's assistant then claimed that I stalked her by going to the city hall and asking too many questions. Asking questions, recording while doing so, and publishing those recordings to the internet is not a crime. Though that won't stop butthurt public officials from kidnapping you for it. After the judge revoked my bond, he said that phone calls made by third parties, of whom I don't know, will be included in evidence to be used against me at trial. So what others have said is being used against me and to paint me in a bad light. Not only that, but the Judge Hunter Reese, who is an ex-cop, is considering allowing my criminal history to be used against me at a trial. Indiana Trial Rule 601, and this is what I believe from memory, it's Trial Rule 601, I believe it outlines the inadmissibility or admissibility of criminal history as evidence in trial to be used against a witness or a defendant. None of my history meets the requirements outlined in that trial rule. It looks as though this will be an uphill battle, especially if my report on the city of Clinton is not admitted as evidence. And it would be admitted as evidence because that was my purpose for being in the city hall. And now I want to talk about the bond revocation, a little bit of an update. When the judge decided that my bond would be revoked and put me into custody of the Vermillion County Jail, the prosecutor, Nina Alexander, this is the assistant prosecutor, put her hand up and asked to speak to my attorney in the back. Those two went to the back into a conference room and came out. My attorney came to me and said, Craig, they just want you to admit that you've done something wrong. And they said they want me to plead a Class B misdemeanor. The charge is a felony. And a Class B misdemeanor is a very minor offense in Indiana. She told me that if I would just sign the Class B misdemeanor plea, that the state is going to, put me on a probation, and they're going to let me out of jail, and I'll just go to Sullivan County and face the charges there. Of course, I turned it down unequivocally. I said I will not be admitting that I did something wrong because it is not the truth. So, with that being said, I went to jail even though I had the option not to. I'm going to end this report by saying a fair trial is a tall order in Indiana. I hope to see you at mine. Stay safe, stay free. Craig Hendry, out. Don't ever be afraid to call your government and tell them that you dislike what they are doing. It is not a crime to express a dislike for your government's actions. There are ways to commit crimes while doing so. You can threaten people. That's a crime. I would not advocate that you do that. But if you want to call somebody and express a dislike with their actions, that is not a crime. As long as that person is a public official, they have no other option but to hear it, but to hear your grievance. With that being said, stay safe, stay free.